E. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within the Commonwealth. Draw near, give attendance, you shall be heard. Now, the Commonwealth of Massachusetts, court is open, please be seated.
Good morning. Welcome to the Appeals Court. I am Justice Rubin, and to my right, Justice Grant. To my left, Justice Hershfang. I apologize for the delay, which was due to circumstances beyond my control, but I'm glad to see that everyone has made it back here. We will hear one case this morning. It is number 22-1087, Commonwealth versus TEIXEIRA, which I may be mispronouncing. The rules of argument here are, as they have apparently always been, 15 minutes per side with no rebuttal. And we will hear first this morning from Attorney McKenna.
May it please the Court. James McKenna for Mr. TEIXEIRA. Good morning. On January 13, 2017, the Commonwealth did exactly what we hope our prosecutors would do. They recognized they had breached the district court discovery order. They realized there was a motion for sanctions pending, and they decided to drop the firearms-related charges. They filed an all pros indicating they would pursue only the more serious charges. That is, that it was an all pros filed on January 13, 2017. And the language of that, it's on our brief on page 22, and if I can read from that, Your Honor. The defendant has recently been indicted for more serious charges, and it indicated they were going to pursue those. This is January 13, 2017.
Well, the no pros says, therefore, it is not in the interest of justice to prosecute in two different courts.
Right.
It doesn't say we're not going to bring any more indictments in the Superior Court.
It doesn't say that, but it indicates that they are going to pursue only the other more serious charges. And then is a gap from January 13 until March 29. At some point between those two dates, they changed their minds. In the other matter...
How do we know they changed their mind?
Because of the language in the null pros, where they talk about how the defendant has recently indicted more serious charges and occurring the same date using the same firearms from the above captioned matter.
Where in the record does it show that your client moved at arraignment in the BMC for a defense expert to be present at the testing of the firearms?
Thank you, Your Honor. If I can go to the record appendix, we've got October 26 motions filed. I believe that's on, I may just have a moment.
The one in the appendix has a caption, Bellarmino Montero, with a docket number of BMC 4073. As I understand it from your client's BMC docket, your client moved at an arraignment for a probable cause hearing.
And also for the order which Judge Grant allowed to preserve the evidence, to make sure that an expert from the defense was there at any testing.
When you say an expert from the defense,
yes,
do you mean the Bellarmino Montero defense, or do you mean the GILSON TEIXEIRA defense?
GILSON TEIXEIRA, Your Honor. And
where in the record is there a motion by your client that was allowed by Judge Grant to have an expert present at arraignment? I mean, at testing.
Your Honor, I'm going to the record appendix right now to track that down.
Do we have a transcript of the arraignment in front of Judge Grant?
We don't. This was 2016. It's difficult to get recordings from that time frame.
Well, given that your client moved at arraignment for a probable cause hearing that was then scheduled for November, didn't that require the BMC prosecutor to make sure that the testing of the firearms was expedited in order to be ready for that probable cause hearing?
That would make good sense, Your Honor. Yes, Your Honor.
So if we have a scenario where there's multiple defendants arrested, and one of them has a gun in his pocket with his fingerprint on the magazine, and then your client has a gun at his feet,
Yes, Your Honor.
if there's a motion at arraignment by the guy with the gun in his pocket to delay testing until his expert can be present, and there's a motion by your client for a probable cause hearing, what's the prosecutor supposed to do?
Not proceed with the destructive testing until we have the expert there. Because, if I can just quickly refer to Record Appendix on page 18, I think it's described at length there. The motion filed on behalf of Mr. TEIXEIRA describes exactly what the court, I believe, is looking for.
That's filed, that motion on RA 18 is filed on behalf of Mr. TEIXEIRA?
I believe that's the motion for sanctions on behalf of him. Yes, Your Honor. And that would describe exactly what the court is inquiring about.
I'm looking at page 18 of the revised appendix that was filed last week, and that's Bellarmino Montero's motion to inspect and/or test evidence with the margin or handwritten margin order from the judge.
Endorsement on page 17. Defendant's motion to inspect with endorsement on page 17. Motion for sanction on page 18, Your Honor, I believe.
So your client moved for sanctions for the failure of the Commonwealth to comply with the discovery order that was entered on the motion of Montero?
I'm just reading on page 18 of the revised appendix. The defendant, Mr. TEIXEIRA, hereby moves this honorable court to exclude firearm and ballistic testing evidence as a sanction under the rule for the Commonwealth's failure to comply with discovery order and the exculpatory nature of the destroyed evidence. And this is a case where there were several defendants moving at the same time. They're indicted at the same time, at Superior Court at the same hearings, and evidently in the same district court proceedings. So I recognize the court's
Your
question.
client was a co-defendant of Mr. Montero at the time the motion was filed.
Yes, Your Honor.
Okay.
So they're all in the same car. They're proceeding in district court
That's
together.
not my question. My question is, if he's a co-defendant, that is, was it clear that were these cases joined or not severed, or I don't know if it's, I don't really know the process of whether things have different docket numbers or not, but I don't see why someone wouldn't be entitled to the benefit of their co-defendant's successful motion. I mean, I guess we could make every defendant file copies of an identical motion, but I don't know enough about this, and we may ask your sister about it as well.
Thank you, Your Honor. They were functionally joined in district court, and then they were together in Superior Court. The transcripts of the Superior Court proceedings indicate that all the defendants were addressing the same matters at the same time, one counsel after the next. So they...
You know if your client was present in the BMC on November 14th, 2016, when Judge Lisa Grant entered that endorsement on Mr. Montero's motion, allowing it?
My understanding is he was, that he would have been there at the time. He's certainly a counsel at that point in that courtroom at the time of that hearing.
When was the testing done? On what date?
My understanding it was done in February, Your Honor. It was done at some time before they were advised of the, before they were advised that it had been done. They were surprised by it having, that it had happened. I'm sorry. It was done before the December motion for sanctions because they weren't.
Is there, how do you know the date? Is there a certificate that's dated the day of the test firing that we have or something like that?
I don't believe that's in the record, Your Honor.
You don't think that's
I don't believe that's in the record, no.
So if counsel for the front seat passenger told Judge Muse at the Superior Court sanctions hearing that the testing was done on November 9th, would you have any reason to doubt that?
No, Your Honor. It would be before the December 2016 motion for sanctions.
And also before the November 14th, 2016 order entered by Judge Grant.
Yes, Your Honor.
Wait. For it to be a violation of the order, it had to take place after the order issued, right?
Yes, Your Honor. My understanding of the order is, let me quickly get to where the order was. The endorsement on, I believe that's on page 17.
Yeah. Endorsement looks like it says November 14, 16 is what it looks like to me, although it may be cut off.
No, it's clear.
November 14, 16. Although no one has argued this, neither the judge below nor, so far as I can tell, the Commonwealth says that there was no order in place. Everyone seems to concede that there was a violation of the order, although I'm...
Yes, Your Honor. That's why I'm stumbling through the record appendix on this, because it's not something which, certainly it's something to
So
consider. But not
assuming
something-
that there was an order in place and it was violated, why aren't we bound by Judge Muse's findings after hearing the testimony of 2 assistant DAs and the administrative assistant that the violation of the order was merely negligent?
We've got to prove abuse of discretion, which is a steep hill to climb. We've got to prove abuse of discretion relative to negligence versus recklessness, which makes it even steeper. And we can here, because Judge Muse, when he looked at this, said that the individuals involved, the prosecutor in Dorchester, the supervisor of the prosecutor in Dorchester, the administrator, the person who sent the report, they committed, at worst, negligence. Judge Muse may not have been wrong in that regard, because each person, someone dropped the ball, perhaps, amongst them, but at worst, that's negligence. That's not why Judge Muse was wrong. That was not the abuse of discretion. As argued by counsel for Mr. Teixeira before Judge Muse, the problem was the office. When Stanford happened, Stanford was the same thing, as Your Honors know.
But Judge Muse heard testimony that the office sent around an email
Yes, Your Honor.
after Sanford instructing the line ADAs in the BMC that if they got an order not to test, that the line ADA and the BMC should be responsible for contacting Boston Police Ballistics directly.
Yes, Your Honor.
And the ADA dropped the ball. So how is the office reckless?
Because the ADA in Dorchester didn't know about the email, the supervisor didn't know about the email,
The email was sent in 2011, right?
it was,
After, isn't that when Sanford was decided?
Sanford was decided in yes, Your Honor, 2011. It was sent after Sanford. It was August 2011 was Sanford. The email was sent thereafter. Nobody involved in this knew about this.
So it wasn't placed into a handbook or a training or anything. An email was sent to whoever was in the office at the time.
Yes, Your Honor.
Do we know if these people were recipients of that email?
We don't. None of these people know anything about the email or about the policy.
And the Commonwealth didn't put in any evidence that they had been on the email or part of the office on those dates or whatever?
Exactly, Your Honor. Nothing.
The line ADA and the BMC didn't testify that he was there at the time and he received the email, he just forgot about it?
Well, ADA Feeney testified that he had signed the notice of appeal in Sanford, and he didn't remember Sanford or any case like it. So he didn't remember it. He had no training. ADA Tome had no training about this. The administrator, Dillon, who sent the firearms to the police, had no training about this. Nobody knew about this. That's the recklessness. After Sanford, there had to be some remedy. There had to be something done to fix the structural problem, or this was going to happen again. And this case is just that. It's where it happened again. Under the standard for recklessness in Clinton.
So if the
Your Honor.
record before Judge Muse included testimony of the BMC prosecutor that his name was on the June 2015 email and he received it, he just forgot about it.
And had no training at all about this.
Well, isn't an email training?
An email could be training, but it could be one of the hundreds he got that week. And there's no indication. The recklessness, the problem was this was going to happen again, unless something was done to correct the structural problem. And nothing was done. So this resulted, pursuant to our argument, this embodied indifference or disregard of probable consequence. This was going to happen again, probably, and it did. And the office, not the individuals, and Judge Muse was frankly right about that. The individual prosecutors were at most negligent. The office was reckless because, Your Honor.
If your client's attorney had shown up at the probable cause hearing in November and the testing had not been done to show that the firearms were operable, would you have moved to dismiss?
It probably, there could have been a motion to dismiss. It likely would not have been allowed at that time. Another date might have been obtained at that point. A further further probable cause hearing could have happened. And what should not have happened was disregard of the court order, testing in the absence of the expert. The whole point of the court order is to preserve whatever exculpatory evidence could be found. And that was breached. And all that exculpatory evidence then was lost. That was lost as an entirely foreseeable, inevitable result of not fixing the problem identified in Sanford.
Okay, your time has expired, but we may have a couple more questions.
I'm hoping that I remember this correctly, but please tell me if I don't. Judge Muse also found that given the subsequent testing in the presence of a defense expert, there was no prejudice. Is that correct?
Yes, Your Honor.
Thank you.
And if I could,
Well,
I know
if you have more to answer, then okay.
I mean, I'm satisfied, but if you think I shouldn't be, please go on.
Thank you, Your Honor. And that goes to the idea that the court orders, based on that approach, there's no reason for the Commonwealth to abide by those orders, because given some of the language in Sanford about how we've got to establish in terms of prejudice that there was something wrong with the gun that you didn't see tested, which can't be done.
Yes, but that's a problem created by our case law.
Which then indicates that the recklessness part should be given
Oh, I
even
see.
a wider berth.
I see. I have one question about the Guardito aspect of this. Prior to Guardito, what do you say was a proper instruction on this crime of possession of an unlicensed firearm, given that the law was that the Commonwealth had no burden to demonstrate absence of licensure? What would be the elements of the offense on which they should be instructed, the jury?
Your Honor, our argument relative to Guardado, it's in the same neighborhood as Guardado. It's not the same thing. We're saying at some point the court should have said it has to be unlawful. The elements as listed by the
And
judge,
if I go back and look at all the Guardado cases that have come down and been, let's just take the published ones, you're saying that I will find in each case that there was an instruction, that the defendant could disprove lack of licensure, or no instruction at all, just mention to them it's an unlawful gun, but we know that wasn't lack of licensure was called not an element of the offense.
Right.
So how can it be an error to not mention not an element of the offense?
It's not licensure. It's the fact that it's unlawful. That's what was missing. If the elements are, if I can just quickly go through them, I know I'm way out of time.
Well, how is if you have to prove unlawfulness beyond a reasonable doubt, and the basis of unlawfulness, as it is in these cases, is absence of a firearm ID card or a license to carry, depending on where the person is, aren't you asking the jury to find that beyond a reasonable doubt, and isn't that exactly what wasn't required?
In most cases, yes, but in some cases you could be being prosecuted for something in your home or business where licensure wouldn't matter quite as much.
Well, you need an FID card, but...
Exactly, if you're being prosecuted under 10A and you're arguing that I was living there and you're raising a defense there, if I could I'm way out of time, but if I could very
Well,
quickly.
we're going to give your sister additional time if she needs it, but a brief, something brief
I
is
just want to
okay.
fly through the instructions this is on page 37 of our brief. The elements are possess the firearm, possess knowingly, firearm meets the statutory definition, and not in the residence or business. Where does it say unlawful? If you
Okay,
possess a gun.
I think we understand that part.
Thank you. That's
All
all.
right, your time has expired. Thank you very much for an excellent argument. We will hear next from Attorney Martino.
Good morning, Your Honors. May it please the Court. Elizabeth Martino on behalf of the Commonwealth. And we're asking that the Court affirm the defendant's convictions because, first, it was harmless error not to instruct on licensure under Guadardo and the subsequent cases on these facts. And second, because the motion judge properly found that sanctions were not appropriate in this case for the Commonwealth's admitted violation of a court order. If I could, I'll start with the first issue, which is the violation of the court order. The court brings up a good point about the defendant's motion. I proceeded as if the defendant had filed the same motion. That was how all of the hearings proceeded in the lower court, and I apologize I didn't catch that in my brief, but it did proceed in the lower court as if the court order applied to all four defendants, and that there was a violation, and I think the Commonwealth conceded sort of at all points. This gun was tested in violation of the order, and we're sorry.
So after November 14th?
The record indicates it was tested on November 7th, 2016, so I'm not sure what that discrepancy is, because the parties
You
did
didn't
all-
argue below that there was no order in place?
No,
Okay.
right, and the parties all agreed, like, this was a violation of a court order.
There's no factual finding by the judge of what date it was test fired on?
No, he didn't make, Judge Muse did not do a findings of fact section, as you would see in like a motion to suppress, but he said, based on the testimony of the individual actors here, I find that at most, the Commonwealth was negligent. So I think he implicitly credits each of the government actors who testified, and their recollection was that the testing was done on November 7th, 2016. That was at the evidentiary
Yeah,
hearing.
but there was no finding that that was correct or accurate. How was that? That was testified to?
Yes.
So there's no certificate, it's just some officer or a ballistics specialist, something?
It was the ADAs who came in. I think it was,
Was it testimony or representation? It was during testimony?
yes, Your Honor, it was during testimony. Yes, it wasn't representing as an officer of the court during
Yeah, yeah,
argument.
I
It was
understand.
testimony at the evidentiary hearing, and Judge Muse did appear to credit the ADA's testimony and the administrative assistant's testimony.
But the ADA and the administrative assistant were testifying about when they asked for the testing to be done by email.
So that was,
Do you have anything in the record that shows when the testing was done?
yes, Your Honor. So on the hearing on November 27th, 2017, let me just get the exact page. At pages, I think it's 28 and 29. They say it was on November 7th. I'll find the exact page. It was on November 7th, 2016. But that, I'll find the exact page, but it is in this November 27th, 2017 hearing, and they do represent that the testing was done November 7th, 2016.
So that's, if the testing was done on November 7th, and Judge Grant's written order was entered on November 14th, do we have anywhere a transcript of the arraignment that was conducted on October, I think, 26th, to see if Judge Grant might have made a verbal order at arraignment?
From the representations in my reading of the record, there was a verbal order at arraignment. I don't have a transcript of that. There is a transcript of the November 29th, 2016 probable cause hearing, where ADA Neil Flynn came down before Judge Grant to explain the violation of the court order, to explain that he had apologized to defense counsel as soon as he became aware of the testing. He called defense counsel to let them know. And it was at that hearing that Judge Grant indicated, well, we should have a hearing on whether sanctions are appropriate. I do have a transcript of that, but it's not part of the record. I can provide it to the court. And all of the record does seem to indicate that there was some type of verbal order by Judge Grant at arraignment not to conduct testing until the defendant's motion to have his expert present was ruled on.
All right. So let's assume that there was an order in place. Everyone's apologizing for violating it. I'm guessing chances are it was violated. There was an order that was violated.
Yes.
I understand it's not an
I actually-
ineluctable conclusion.
No, I actually think, yeah, I do think that what happened was there was an oral order that said, don't test until I issue my ruling, and I think the ruling was on November 14th.
Okay.
There's also an oral order for a probable cause hearing.
Yes, Your Honor. So, and I think that's a good point. Thank you for bringing up these competing interests that were incumbent on the DA's office, both to have speedy testing of all of the relevant evidence, as well as to comply.
If a court, and I don't think these are, but if a court, at least as described, but if a court orders two things and it's impossible to comply with both, you don't just comply with one of them, right? You go to the court and say, what would you like me to do about this?
Absolutely, absolutely, Your Honor. And the Commonwealth does acknowledge the violation of the court orders.
So
to the
let's
question-
talk about if we can, for a minute, and we can get back to if there's, okay. So my question is, so the prior case, whose name, of course, I've now forgotten, Sanford, is decided. What should the ADA's or the DA's office have put in place to make sure this didn't happen again?
Well, I think the DA's office tried to address the problem by sending out an email. It was sent out from the training department.
Do we have a copy of it in the record?
There's testimony from David Fredette, who was the chief of training.
Okay.
He came in and testified at the evidentiary hearing and said, I sent out an email to the office in 2015 letting ADAs know they should work directly with BPD when these sorts of orders are entered or pending. And ADA Tomei, who was the ADA who stood up at arraignment, acknowledged that he did not comply inadvertently.
Did he acknowledge receiving that email?
He said, I was in the office at the time. I probably got the email. I don't know why I didn't comply. But he said it was inadvertent. So that's in the record. That's their testimony. And I think it does.
And he's the person who actually called the ballistics people and said, could you test this? Or sent it to however the DA requests a test.
No, Your Honor.
He was not the point person on that.
No, Your Honor. So the ADA who stood up in district court, ADA Tomei, he heard Judge Grant's order, delay until I rule on that ruling, on that motion about the defense expert being present. So he put that in an email, which goes up to the Superior Court, because when there are cases that have dual jurisdiction, they automatically get sent for review in the Superior Court. ADA Tomei put in that email, please review. Just to note, Judge Grant said to delay testing until the motion was ruled on for the defense expert. Simultaneously,
Emailed it to the court?
No, to the Superior Court ADAs to review.
To the Superior Court ADAs?
To review for indictment.
Okay, and what did they say? Did they testify at this trial, or hearing, I mean?
One of them did. So what happened, though, when Tomei sent that up to the Superior Court ADAs, simultaneously, there's an administrative assistant who did testify who is responsible for getting testing done. So latent fingerprints, ballistics, all of the forensic testing that needs to be done in a timely manner. So he, not realizing the import of that, Judge Grant issued an oral order, sent the ballistics to BPD, forwarded it to BPD.
Is he a lawyer?
He's not, Your Honor. He was an
Okay.
administrative assistant.
So there's a lawyer who supervises him or trains him, right? Or something.
Who's responsible? Yeah, so that's where
Did
it was
he
sent to
testify
BPD.
about knowing anything about orders for not to do destructive testing?
He said prior to this, he was not aware, but since this, he became very aware, and the whole office worked to remedy the situation.
So I guess my question, if I'm understanding, and I don't know, I have to read the transcript carefully and see what was actually raised, but I take it what your brother is saying is there's recklessness there. Your person who requests these things doesn't even know that there's a thing called a court order not to do destructive testing, and therefore maybe it's not their fault. They're not being reckless. They don't even know about it. But whoever is supposed to have told them never did, and that was reckless. What's your response to that?
Right, and that is indeed the defendant's argument. The response is that Sanford was a ballistics testing case. There was a violation of a court order. It was a little bit different because that was over sort of more at BPD's fault but regardless, all the government. And the DA's office responded by having the training, chief training officer let people know in the DA's office, listen, ADAs have to work with BPD directly because these orders are coming more often, so please do so. So the DA's office responded
But
when
no
there
one
was
in the DA's office ever told the person who actually makes the requests.
Right, Your Honor.
Why isn't that reckless? I mean, that's the person who needs to know. Right, on their checklist every time should be like, is there an order prohibiting this, right? I mean, or something, I don't know.
I absolutely understand your point, Your Honor, but I think, and this was all before Judge Muse, and argued before Judge Muse that this was a collective problem and a failure of the entity and all of the things. But I think what the record bears out is that there was an error, a similar order that was not followed. The DA's office tried to respond with additional training. There was another human error here with this one administrative assistant who was not
Were the other
trained.
administrative assistants all told about this?
It's not in the record, but presumably there was something that went out to
I'd say
everybody.
presumably there was nothing because this one didn't get one,
Well,
right?
but my memory is that he had only been there a week or two.
4 months, I think.
4 months, okay.
But again, this isn't a systemic problem. The defendant has not established that this administrative assistant, by his lack of training,
Systemic problems are caused by people.
yes, but they're not, so I understand Your Honor's point, but in order to reach recklessness and bad faith such that,
Or bad faith.
yes, such that prejudice can be presumed, it needs to be either intentional or knowing that substantial harm here is going to result. This, as Judge Muse found after hearing all of the evidence, was, look, the DA's office tried to respond, tried to train. There was a human error here. It was not a systemic problem. It was at most negligence or inadvertence. Let me now balance
Well,
that
he does say the
culpability.
individuals were negligent. Right, but you're saying, I think correctly, that what we're talking about is whether the office had put in place or had recklessly failed to put in place a procedure.
Right, and I think it's a combination here that the office was trying to respond, that perhaps it was not the most robust response and that there was a human failure here. And then after, but it was not, a defendant did not establish, this was a lack of training that has resulted in multiple instances of violations of discovery orders. They said, here's this one. The motion Judge Muse responded appropriately by calling in all the government actors, having an evidentiary hearing, saying, I'm going to determine the culpability of the government here, both individually and as an entity. I'm going to make findings, I'm going to make rulings, and I'm going to determine what the culpability is. And that's important because the culpability, the level of culpability then informs what level of prejudice needs to be established, right? And even if there's recklessness or bad faith, prejudice still needs to be established. The only time it need
No,
not be
that's not
established.
right. That's not right. It says there's two ways you can do it. We can't tell if there's prejudice, obviously, because there wasn't a person there to see. And ordinarily, the Commonwealth, despite having violated the order, gets the benefit of that unless it's reckless or bad faith, as I understand it. Now, maybe it's a presumption of prejudice.
The presumption of prejudice.
Okay, but it's done with the finding of
Well,
recklessness
no,
or
and
bad
then
faith.
it says in Sanford specifically that it then shifts to the Commonwealth to disprove prejudice, which I think the record here does amply, because this was a shooting. This was not just a possession of a firearm. That gun was operable at the scene. There's matching ballistics that show that that gun was fired, those guns were fired at the scene. So they were operable. And the defendant, after being given multiple invitations by Judge Muse to please file something or get up and argue something to establish prejudice, never did. And they had their expert testify the firearms. This is not exhaustive testing like DNA. This is just, is a firearm operable or not? And there was no question, given that this was a shooting, that the firearm was not operable, which is very different from Sanford, which was a straight firearm
Why do you do
possession
the
case.
testing?
I'm sorry, Your Honor?
Then why do you do the testing?
Because the Commonwealth has to prove beyond a reasonable doubt that it's an operable firearm is an element of the offense, and usually they do that by getting ballistics testing. I also will note, Your Honor, that this started as a firearms possession case, which then became a shooting case once the Commonwealth looked at video that tied the defendant to the shooting. The ballistics testing was ordered when it was a straight firearms possession case. But I would like really just to, I'm sorry, I see my...
Your time's expired, but he had 4 extra minutes, so we can go a little.
I just do want to quickly sort of clarify Sanford, because, and which goes with Williams and Neal's, this is the prejudice, cases, the lost or exculpatory evidence cases. At the outset, the defendant has to prove prejudice, that evidence lost or destroyed was exculpatory, and that he was prejudiced by the loss or destruction of that evidence. Only then does the judge look at the level of culpability to measure the culpability against the materiality of the evidence, and then determine whether some type of remedial measure can make the case fair. That's the purpose of the system. In cases where a defendant cannot establish prejudice, the exculpatory nature, because the evidence is lost or just completely destroyed, there's, as Your Honor mentioned, a presumption of prejudice, but only upon a showing of culpability that's bad faith or recklessness, which really indicates an intentionality to deprive the defendant of something. And still, it then shifts to the Commonwealth to disprove prejudice. So the only time that there's not prejudice needing to be shown is when there's egregious governmental misconduct, which nobody is alleging here. So prejudice is the thing, and it is not established anywhere on this record. The motion judge did look to the culpability of the actors because it's a balancing: culpability, error, remedial options. And the judge found no remedy was appropriate.
What should the jury have been instructed here?
Oh, thank you, Your Honor.
I mean, you're late.
At page 51 and 52 of the transcript from October 28th, 2021, they were instructed on the elements of unlawful possession, and the judge says, the defendant is charged with unlawful possession of a firearm in 2 counts before you, and then goes through the elements. So he did.
So you agree that the word unlawful has to appear in the instructions, or you're not instructing on a crime, even back when the affirmative defense was?
I don't know whether I agree, but it was done here, so I think it obviates the argument. It was instructed in...
Well, but when he got to the elements, or she, I don't know who the judge was, they weren't, it wasn't mentioned. I mean, the elements could have convicted a licensed person. Was there a request for an affirmative defense instruction
No,
on licensure?
The case that I cite, the SJC case, Bookman, that's the case that says where an officer testifies that the defendant did not have a license, it's uncontested, unobjected to.
What's that case?
I'm sorry, it's cited in my brief, Your Honor. It's a Bookman, I believe. It's the Bookman, 492, Mass 396. 2023 case, and it says it's a harmless error beyond a reasonable doubt. If an officer testifies that the defendant was unlicensed, it's unobjected to, and it's not contested at trial, which was the case here. His defense was, it wasn't me.
Okay. Are there other questions? Your time has expired. Excellent argument by both of you. Very, very helpful to us. The case is submitted, and as that is our only case for today, we stand in recess. I'd like to thank the court staff and especially court officer